Hello again, everyone. I'm Professor Robert Romano, and welcome to Module 2. This module, we're going to be going over the powers of the various league commissioners. We'll be exploring basically how much power the league commissioners actually have. And it's based on a term called the best interest of the game. Each league commissioner is vested with the power to do what's in the best interest, subjectively, what they feel is in the best interest of their league at that time. And this stems from the case in the book that I wanted you to read, Charles O. Finley versus Bowie Kuhn. It's a federal case back from 1978, but it pretty much lays the groundwork for how and where the commissioners get their power. The facts of Finley versus Kuhn are interesting to start with. Number one, we got to figure out who the players are. The commissioner is Bowie Kuhn. He's the commissioner of Major League Baseball at the time. He is sued by Charles O. Finley, who is the owner of the Oakland A's. What's interesting about this, if you think about it, it is the employer suing his employee. Because the commissioners work for the owners. They are hired by the owners. They're hired by the owners, and basically they are their bosses. The owners are the commissioner's boss. So in this instance, it's kind of interesting to see that an owner is suing his employee. What's also interesting about the fact of the dichotomy between owners and commissioners is that commissioners have the power to sanction or punish their bosses, the owners. It is done frequently. I mean, last year, Roger Goodell fined the owner of the Indianapolis Colts. Fined him $500,000. So it's interesting how this works. The commissioners are hired as employees of the owners, but are given a substantial amount of power, even the power to punish their bosses. Something you usually don't see in the regular employment context. So in this case, Charles O. Finley, the owner, sues his employee, Bowie Kuhn, saying that, the Commissioner's Kuhn disapproval of a trade that Charles O. Finley made, that being the trade of three players, Vida Blue, Rollie Fingers, and Rudy to the Yankees and the Red Sox, was wrong, right? Commissioner disapproved the trade, in his opinion, saying it was inconsistent with the best interests of baseball, because he had concerns about the debilitation of the A's at the time, getting rid of three of their starting pitchers, lessening the competitive balance, putting all these players on the Yankees and the Red Sox may disrupt the competitive balance of the league. I mean, you don't want all the power and all the wins coming from two different teams. And the current state of the reserve clause. A lot was changing at this time, 74, 75, 76, 77, with regards to the reserve clause. And we're going to go over the reserve clause in more detail in a later module. But just the reserve clause was a clause that was in every player's contract. It basically gave the teams the rights to reserve that player. Like I said, we'll go over it in more detail later on. But it was changing. The reserve clause was challenged in the Supreme Court. And then they were going, at this time, 75, 76, there was a lot of changes in how the reserve clause was going to continue. So Bowie Kuhn, the commissioner at the time, said, I'm going to disallow this trade because I feel it's going to debilitate the A's, lessen competitive balance throughout the league, and we're not sure about the state of the reserve clause, so until that issue settled, I'm going to disallow this trade. Charles O. Finley, not being happy and being a red-blooded American, sued. And his issues were whether the commissioner has this authority. Can the commissioner, Charles O. Finley followed the league rules. He didn't do anything wrong. He followed the rules of the league. made trades, got money in exchange, which was perfectly legal at the time. So his issue was whether the commissioner had the authority to disallow a trade that was perfectly within the rules of Major League Baseball. And then his second issue was whether the waiver of recourse provision is valid and enforceable by the court. There was a waiver of recourse in the bylaws, the Constitution and bylaws of MLB, saying no, you cannot use the court proceedings. Everything has to be done through arbitration. So this whether or not this waiver of recourse provision was valid and enforceable was Charles O'Finley's second issue. Charles O'Finley's arguments were that the commissioner's actions of disallowing the trade were arbitrary. Well, what does that mean? The commissioner's actions were arbitrary. Well, arbitrary being defined as a decision that is not based on reason or judgment, but on personal will or discretion without regard to the rules or standards. So Charles O'Finley's first argument is that the commissioner's actions aren't based on any reason or judgment, and they're in total disregard for MLB's rules. He also argues that Commissioner Kuhn's actions were capricious, unpredictable, subject to a whim, unreasonable, discriminatory, and contrary to precedent, tradition, and prior rulings. And more importantly, they're procedurally unfair. I followed the rules. I did what I was supposed to do. I followed all the procedures. You as a commissioner disallowing the trade was procedurally unfair to me and to the teams who wanted these players. Well, we have to ask ourselves, what is the commissioner's authority? If Charles O'Finley is challenging the commissioner's authority to disallow the trades, what is the commissioner's authority? Where does the commissioner get his authority from? And the commissioner's authority can be found in the rules, in the contract, the Constitution and bylaws of Major League Baseball. So, in thinking about this, we've got to go back in time. The contract, or the powers of the commissioners, came into play in roughly 1921. In 1920, as per the opinion, in November of 1920, the owners got together, the Major League Baseball owners got together, and wanted Kennesaw Mountain Landis, then a federal judge, to be the first commissioner of Major League Baseball. However, they put limitations on the commissioner's power, saying, we're going to limit your power. You're going to be the commissioner, you'll be the figurehead, but we still rule the roost. It's our league. Blah blah blah. Commissioner Kennesaw Mountain Landis refused to accept the position, saying, "Listen, I need full power. I need total authority if you want me to be the commissioner of this league." I want you to think about that. Why? Why would Kennesaw Mountain Landis insist that he has full authority, full power? And the reason is, if he doesn't have complete authority, he's going to have, at this time, I think there were 16 teams in the league, he's going to have 16 different bosses telling him 16 different things to do. And he's not going to be happy. So boss A is telling you this, boss B is telling you that, boss C is telling you this. If he's got to listen to all these different owners, he's never going to be able to get anything done. So in order to have an effective commissioner, the commissioner needs complete authority. Now, the owners finally came around to this. And on January 12, 1921, they reached a major league agreement wherein the commissioner had the power to investigate any act, transaction, or practice to determine if it is in the best interest of baseball. They gave the commissioner complete authority. He, in this case, Kennesaw Mountain Landis, had the power to investigate any act, transaction, or practice, and it was up for the commissioner to determine if it was in the best interest of baseball. They also gave the commissioner the power to punish. Okay, so he had the right to determine what is in the best interest of baseball, to do the investigation, to determine if this act was in the best interest of the game. And if the commissioner thought it wasn't, he had the right to punish. And the punishments were threefold: preventative, in this case, what we have here, stopping a trade; remedial, or even punitive in nature. So the Commissioner Landis got broad authority. He got a lot of power. He had the right to investigate any act. He had a right to determine if it was in the best interest of baseball based on his subjective beliefs. And further, he had the right to punish, all right, to prevent things, and even be punitive in nature. And part of the commissioner's authority was that no assignment of a player is valid unless it is approved by the commissioner. Even if you follow the rules, even if everything is done procedurally correct, it still has to go through the commissioner's office, and the commissioner has to sign off on that trade, on that assignment. And that is still the rule today. All trades, all contracts have to go through the commissioner's office, and the commissioner's office has to sign off on it. It is not a valid contract until the commissioner's office signs off. All right, so there's been many times in the past where the commissioner's office has there have been trades and the commissioner has disallowed the trade. And this, the owners ratified this, and they agreed that they would be bound by the decisions of the commissioner. They would abide by any discipline imposed, and they waived their right of any recourse. They waived their right to go to court. All right, so they gave the power to the commissioner. They gave them the power to investigate. They gave them the power to determine whether it was in the best interest of the game. They gave them the power to discipline, and the owners agreed that they would be bound by the decisions of the commissioner and bound by any discipline that he imposed, whether it's remedial, punitive, or not. And they waived their right to go to court. Okay? And this was the law, or these were the rules that were in place, or the law of Major League Baseball, until Judge Landis died in 1944. He was a commissioner for over 20 years, and he reigned with all the power that was given him. And after his death, Major League Baseball, the owners got together and amended the Major League Agreement. They amended it. The waiver of recourse was deleted. They said, no, we want a right to go to court. We want a right to have a review by a federal district court or a state district court, probably federal. We're going to delete that provision. They also added Article 1, Section 3, which said no rule or no action or procedure taken in compliance with any such rule shall be considered detrimental to baseball. Think about that rule. Think about Article 1, Section 3. What does that mean? No rule and no action or procedure taken in compliance with any such rule shall be considered detrimental to baseball. What this means is, if an owner trades a player in accordance with the Major League rules, doesn't violate any of the rules, the office of the commissioner cannot disallow it. Okay, so as long as the owners, as long as everybody plays by the rules, as long as it's done in conjunction with all the other rules under the Major League Agreement, it can never be considered detrimental to the game of baseball. All right, so Judge Charles O'Finley's case under this rule would be, hey, listen, I followed the rules. I didn't do anything wrong. Therefore, it cannot be considered detrimental to the game of baseball, and therefore, the commissioner can't disallow the trade. And that was under Article 1, Section 3. And Article 1, Section 3 stayed in play until 1964. For roughly 20 years, these two, the waiver of recourse, deletion, and Article 1, Section 3, were in place. But what the owners realized was, there's too much controversy. This isn't good for the game. Owners are taking advantage of it because that's what they do. I mean, they're smart people. So they decided to go back to the way it was. Okay, they decided to go back to the original agreement that they had under Kennesaw Mountain Landis. All right. And they also decided, well, we're going to reinstill the waiver of recourse. All right. We're going to keep this in our chicken coop. We're going to we don't want any outside interference on this. So basically, they set the rules back in 1921, gave complete control to the commissioner. When Judge Landis died, they revamped, they removed the waiver of recourse, and they decided to say that anything which is in compliance with the rules can never be determined detrimental. However, 20 years later, they went back to the original agreement, what it was under Kennesaw Mountain Landis. So with that backdrop in mind, the district court found that Article 1, Section 3 precluded the commissioner from finding any act that complied with the rules to be detrimental to the best interest of baseball. The court found that. Okay, but they still disallowed the trade, which is kind of interesting. But we're going to get into that in a little bit further down the road. This matter was appealed. It was appealed to the appellate court. All right, Judge Charles O'Finley appealed to the appellate court again with his arguments. The commissioner's actions were arbitrary. That his decision was not based on any reason or judgment, what was personal will, but on personal will or discretion without regard to the rules or standards set. The appellate court analyzed this. They looked at it. They said, well, that's not true. The Commissioner Coons' decision was based on reason or judgment. All right, it was based on the fact that there was ambiguity and controversy with what was going to be happening with the reserve clause. That he wanted to keep competitive balance within the league, which is important. Parity within the league is important. And appellate court said, well, yeah, he was also worried about the debilitation of the A's team itself. So, no, Charles O'Finley, Commissioner Coons' action of disallowing the trade was based on reason. It was based on his judgment. It wasn't personal will. And it was within the rules. The rules being that all trades have to go through his office. And if he felt that they weren't in the best interest of the game, he could disallow it. So the appellate court said, no, Charles O'Finley, the commissioner's actions were not arbitrary. They were reasoned. They were reasoned decisions. Charles O'Finley went on to say it was capricious then. His actions were capricious, unpredictable, unreasonable, discriminatory, and contrary to precedent, tradition, or prior rulings. Again, the appellate court analyzed this, and they found that not necessarily. This wasn't unpredictable. This wasn't unreasonable. This wasn't discriminatory or contrary to precedent. Because the commissioners have been doing this all along. Commissioners routinely disallowed trades. Commissioners routinely did what was in the best interest of the game. So there have been many instances previous to this instance, where the commissioners disallowed trades, did what was in the best interest of the game, and said, no, owners, you cannot do this. So, no, Charles O'Finley. Commissioner Coons' actions were unpredictable because it's happened before. They weren't unreasonable, discriminatory, I don't understand that argument, or contrary to precedent. Because there have been many times where the commissioner has disallowed trades. Charles O'Finley's final argument was that it was procedurally unfair. The court said, yeah, maybe procedurally unfair to you, but you allowed the commissioner to have broad authority. You're an owner. You agreed to the Major League agreement. When you bought your franchise and brought it into Major League Baseball, you agreed to be bound by all the rules. And those rules vested the commissioner with broad authority. He may have had limited authority previously in that gap between 1944 and 1964, but no. You, in 1964, again gave the commissioner that broad authority to disallow trades, even if they comply with the rules of Major League Baseball. Charles O'Finley, not wanting to stop, said, okay, all right, maybe I lose on that, but I still have a right to come to court and have the court review and analyze whether the commissioner's actions. Charles O'Finley's arguments on this were that the waiver of recourse waivers of recourse are against public policy, and they are. Waivers of recourse can be found to be against public policy, but only under certain circumstances. When there is unequal bargaining power, and there's a waiver of recourse provision, when that waiver of recourse is not voluntary, knowing, or intelligent, or not freely negotiated. All right, so yeah, Charles Finley, you are correct. Waiver of recourse provisions can be found to be against public policy, but only if they are found not to be voluntary, knowingly, or intelligently entered into, freely negotiated, or influenced with unequal bargaining power. And in this case, well, you're a bunch of owners. All right, you voluntarily joined the association. You voluntarily became a major league owner. You voluntarily came to the bargaining table. You voluntarily agreed to the major league rules. You did so knowingly, intelligently, and you may not wanted it, but you had equal bargaining power with all the other owners to negotiate it. And the other owners, or maybe even you at the time, said, no, we want this waiver of recourse in there, so it's in here. I mean, it wasn't like this was forced down your throat. It wasn't like you didn't have any say in it. No, it's Major League Baseball is a voluntary organization, and the owners agreed amongst themselves and negotiated amongst themselves, all with equal bargaining power, to have this waiver of recourse provision within the Major League rules. Charles O'Finley's arguments was rules disregarded the law of the land. The association fails to follow the basic rudiments of due process. Not necessarily. Court's holdings regarding waiver of recourse is that they are upheld. All right. They are upheld as coinciding with the common law standard of disallowing court interference. If the parties agreed, and the parties had equal bargaining power and it was freely negotiated, to place a waiver of recourse into their rules, the court is not going to interfere with that. You guys are big boys and big girls. If you want this provision in there, we're going to allow you to keep it, and we're not going to interfere with it. You decided that you wanted it, fine, now you have to live with it. Even in the absence of a waiver of recourse provision, but this is how it's done, the courts don't like to interfere with disciplinary matters of voluntary associations. All right, it's a voluntary association. You don't have to join. It's not mandatory, and there's discipline matters within that organization. Courts aren't going to interfere with that. It's a voluntary association. You don't have to join. So, what I want you to think about, is this best interest of baseball standard that has been adopted and applied and permeates throughout the major properties, through Major League Baseball, the NFL, the NBA, Major League Soccer, the NHL. That the commissioners have this broad power, or this broad subjective power to do what they feel at that time is in the best interest of the game. And I want you to think about this standard, and how it applies to the Alex Rodriguez versus the MLB and its complaint. Was Bud Selig doing what was in the best interest of the game? Was he following the rules? Was he stepping outside the rules? And analyze whether Alex Rodriguez had a case, had some arguments that the Bud Selig stepped out of his role, was doing things that were arbitrary, were doing things that were capricious, outside of the rules, unpredictable. All right. Thank you. If you have any questions, please feel free to reach out. I can be reached at via email, my cell phone, which is 203-777-9797, or we can always Skype. Thank you.